Okay, great. Thank you, Maggie. It's so nice to be here with all of you, even if it is virtually and I can't see all of you. I know that you're out there, and so I'm glad that you have an opportunity to join us, and hopefully you'll gain a little information that will be useful to you as you think about venturing back into the workplace. As Maggie said, we're going to allow plenty of time for question and answers. I will tell you that having done this enough before, it is a little bit difficult for me to be talking and reading the PowerPoint, or knowing what I'm going to say next, and keeping track of the Q&A in the chats. So if I see a question that comes in that way and it relates to a slide that's up, I will be happy to address it. But please don't think I'm ignoring you or be offended if I don't see a hand raised or whatever. I'll ask Maggie, since you can control that audio, I think, if someone does have a hand raised, because I'm not seeing those. So if someone has a hand raised, then feel free to unmute them and they can ask their question. I don't mind having people ask questions during the presentation. That's the way I would prefer it if I were live. It's just a little more logistically interesting when we're not live, or at least in the same room. So happy to do that. And then if I don't see all the questions or we don't get to them during the presentation, there will be time at the end, and then we can I can read the chats, or you can ask your questions when you're unmuted. So all that aside, let me tell you a little bit about myself. So I work as an attorney, a shareholder with Nyemester Goode Law Firm here in Des Moines. We do have offices in Ames and Cedar Rapids as well. I have been here actually just this week, celebrated my 20th anniversary here at the firm. So I've been doing this for maybe longer than I care to admit, but have been representing employers for a long time. And so I deal with everything from FMLA to breach of contract, reviewing handbooks, working out severance packages, dealing with sexual harassment, race discrimination, all of the things that involve the employee-employer relationship. And so I do the reactive side of things when an employer-client is sued, but I also do the proactive side of things, and that's what I really enjoy doing the most, and that is proactively counseling employers, the HR folks of the world, through their day-to-day issues, and doing training like this. So I have become a little bit of a COVID expert, I guess, by necessity, as have many of you, I have no doubt. This has certainly been interesting times for the last several months. And so, it seems like every day we get different advice or new information from the CDC or from the federal government or the Iowa Department of Public Health. There's a lot of information out there, and sometimes it's hard to know who has the right information. So I'm going to do my best to guide you through some tips, some things that I have learned over the last couple of months as we navigate the COVID pandemic situation. I will tell you that, the focus of our talk today is getting back to work. And frankly, the going out was a lot easier than the coming back, right? We all just kind of decided whether we were ready or not. There wasn't a lot of time to plan. Everybody just went home. And we kind of learned as we went as to how that was going to work, particularly from a technology standpoint. And some of you may not ever have been working at home because your jobs and your employees' jobs aren't like that, right? You're out in people's locations, you're out in hospitals, you're in facilities. And so I recognize that not everyone is in the same situation by any means. But we have had to navigate a lot. And so now as we try and think about, all right, it's time now to get back to the brick and mortar of our workplaces, whatever that workplace might be. So that's what I'm going to focus on today. And we're going to talk first about, we even have to make the decision about, do we return, right? If we decide to return, then there's a whole bunch of, the rest of the presentation is about what to do after we decide to return. But there are still a lot of employers who are in this decision-making process right now about to return or not to return. So things to think about, if you're going to return to employees to a brick and mortar location, we have to think about personal protective equipment. We have to think about masks and gloves, We have to think about plexiglass and spacing and those kinds of things. We have to think about business survival. And I'll add here for this group, we have to think about client survival, right? We have to think about who we serve and what their needs are and how can we continue to best serve that population, and can we do that remotely, or do we need to be back at work? Those are considerations we need to consider. Can we be as productive? Can we be as collaborative? Congeniality is important in every workplace I know. Do you have access to the technology, both at home and now back into the brick and mortar? And what is it like with our mental health? I will tell you that just from personal experience, and I suspect that many of you are in the same boat. When we first went out, I mean, I started working from home March 17th and did not come back fully to the workplace until Monday, yesterday, really. In maybe here and there to print some things or, something, but really not back in the office fully until this week. And so, at first it was the sense of, oh my gosh, this is horrible. How do I do this? How can I work from home? I really hated it because while I could technically do it, there is a lot of lost congeniality that's very important to what I do. And so that was very hard. And I really wanted to get back, and I kept thinking, oh my gosh, every week that goes by, it's going to be that much harder. And that's really true, right? Because we get to kind of the top of the bell curve and over and start thinking, maybe being in my little cocoon isn't so bad. And so it's almost like a situation where, like Helsinki syndrome, where you start identifying with your situation, with your captor, because now we almost feel like we'd rather stay home. And so then we start to think about, well, maybe the workplace has changed, right? Maybe our workplace isn't back at the office or in some other physical location. Maybe it is back at home. And that's kind of what I mean by the American dream, staying at home. I mean, is it really advantageous then? Do people want to be at home? And some of them probably do. And so then we have to think about, well, maybe we are more productive if we're at home. These are the issues that you have to weigh: mental health, personal needs, daycare issues, and we're going to touch upon some of those issues because they are very important as we do think about getting back to work. But those are some of the issues that are unique to each business and each entity. So let's start with kind of the pre-return checklist, if you will. And, to paraphrase Benjamin Franklin, failing to plan is just planning to fail. I mean, we use that phraseology often, but I think it's really, really true when it comes to returning to work after a pandemic like this. I talk as though we've done this before. We have never done anything like this before. So this is new. And I think it's important that your employees understand and your partners understand that we're feeling our way a little bit. We're doing the best we can, but communication and saying we're not sure where we're going to be on August 1st or where we're going to be on July 1st. These are our best plans right now, but that may change depending on the direction that we get from CDC or from the Iowa Department of Public Health. So we need to be flexible, but we also need to have a game plan. So you need to think about what kind of plans should be in place. You need to think about your physical space. If you think about Hy-Vee, right, or any grocery store, and you need a mask, and there's signage everywhere, and there are people wiping off the carts, and you can use hand sanitizer, and there are all those directional arrows and the big circles that you stand on to keep your physical distance. That kind of planning and preparation is not limited to grocery stores or home improvement stores. We need to use that same kind of thought process when we're thinking about our own workspaces. I will tell you, here at Nyemester Goode, we have 4 floors, and we're downtown Des Moines, and we don't have directional arrows, but we do have spaces like circles, like reminding people to keep your physical space, keep your 6 feet apart. And we do that at the entrance to rooms where you go, like the refrigerators, the microwave, the copy rooms. We're not wanting people to be having more than one person in the copy room. We are not serving coffee. I brought my own Keurig machine into the office because that is not something that we're not encouraging people to use any coffee or water service or bring any food in to share or anything like that. So you need to think about preparing your physical space. You need to think about requiring or what required supplies you're going to need. Is that going to be additional Clorox wipes? Is that going to be masks? We have encouraged our employees to bring their own masks, but we will provide them if someone doesn't have one. So that's something to think about. Really controlling access if possible. Now, some of your locations, some of your workplaces, you know, access to your clients may not be something that you can control or want to control. I mean, we want to control it, but we may not be able to prevent access. And so you just need to think about what's the plan, right? Are we going to allow people to be in our waiting rooms? Are we going to allow visitors at all? Should our vendors all be required to use a certain door, and maybe we try and require deliveries to be made during certain times of day, and here's the process, so that we can try and keep those people, so that we know where everybody's been. And I do see that we have a question, and so while we're talking about this, the question was, can we require staff and visitors to wear masks? And the answer is you can. It may feel odd to do that, but it's really no different than requiring employees to wear a uniform, for example, or to wear PPE, other PPE, before we had the masks for everybody in the COVID situation. If a visitor balks at wearing a mask, then you're not required on a private location, you're not required to admit them. Public property is somewhat different, but for private locations, that can be the ticket for admission, if you will. So yes, you can require that. Now for employees, there are two things that I would say on requiring masks that you need to be aware of. If someone were to make an objection based on a medical reason, we need to think about that. There are certain conditions that I can think of, like COPD, for example, where having a face covering may be actually more detrimental to that employee than wearing one. And so if someone has a medical objection to wearing a mask, then they need to get a doctor's note, and then we're going to have to make additional physical spacing accommodations as best we can. The other reason that someone might object, although somewhat more rare, is based on a religious objection. So we have seen some of those. I personally have not seen any of that here in central Iowa, but I do know from talking with colleagues that those are some issues that people on the coasts are facing, that people say that they cannot wear a mask for religious purposes. And so that might be something that you could run into where we need to then decide, can we accommodate this or not? Good question. Okay, so we need to think about social distancing plans. You need to think about returning employees to work and how that's going to work, how you recall them. Do you do it in waves? And we'll talk more specifically about that here in a slide or two. Think about addressing employee pay and benefit concerns. Unfortunately, you know, as we return to work, we're probably going to have more positive tests, more infections. And so I really think it's a matter of not if it happens in your workplace, but when it happens in your workplace, whether it's now or whether it's in a second wave that may happen this fall. We need to prepare for the fact that someone in our midst, in our workplace, is going to have an exposure. And is going to be infected. And so what are we going to do about that? So that I don't forget, because it's top of mind right now, if you have that situation where someone is infected, you know that they have tested positive, we have to alert our employees, and that's why we're going to talk about contact tracing and making sure we know where they've been and who they've been in contact with. But you have an obligation to let your employees know that they may have been exposed if they meet that exposure definition. But we are never going to reveal the name of that person. And I know you all have confidentiality and HIPAA and things like that at top of mind. Same holds true here. Even if other employees can figure out who it is by process of elimination, we are not going to be the ones that would spread that nor confirm that. If the employee wants to do that himself or herself, that's one thing, but we as the employer would not be in a position of doing that. Okay. So when we're talking about workplace safety and talking about the plans, I've mentioned social distancing several times, and that's important, whether you're at the grocery store or at work. And we want to keep as much social distance between us as possible. The CDC recommends 6 feet. And really the masks come into play when social distancing is not possible. Now, I will tell you that our office has instituted masks anytime you leave I have an office with a closed door, and anytime I go outside that closed door, I need to put on my mask, even if I don't run into anybody else on the way to the bathroom. So you can certainly do more than what the CDC requires, and I think that's probably what most employees expect. So let's talk a little bit about screening and tracking, because again, just to give you some examples that I can share with you from my own experience here at our firm, we have 4 floors, and so we have limited everyone to stay on their floor. So that means that I can't go up to the mailroom, I can't go to our library. If I want things from those locations, I need to put in a request, and then someone will bring it to me. It seems a bit perhaps like overkill, and maybe it's more important or more applicable in a larger workplace. But one of the reasons why we are doing that is because if I do get sick, and then I show them every place I've been, and I have been on my floor only, the deep cleaning that we're going to have to do is obviously going to be a lot less from a time perspective as well as a cost perspective. When we got estimates to deep clean each floor of our location was $5,000, and so obviously it's a cost consideration of doing that deep clean if you need to. So we hand out maps, or people are supposed to print maps each day to basically draw a line of where they've been in the office and what they've touched. And so, I think I could use the same map probably every day, because really it's just get off the elevator, come to my office, go to the bathroom, come back. But if I were to go somewhere else, then I need to track that so that we can go back. If heaven forbid, we need to know exactly where everybody has been. So it really is important to know where you've been. The CDC is defining exposure as someone who has been in close contact, that means within 6 feet, for a period of time. And I think the CDC is saying 10 minutes or longer, an extended period of time, and you haven't had a mask, but that exposure anytime 2 days or 48 hours prior to when the symptoms first presented themselves. So, if I got sick tomorrow, we're looking back 2 days. We're looking back to Monday to see where I've been, to know who has been exposed. I have on the screen taking temperatures, and I've been asked a lot about taking temperatures and asking health-related and travel questions. So with respect to temperatures and health-related questions, pre-COVID, these were inquiries that are considered health-related inquiries, and they were not permissible because of the ADA. The EEOC that administers the ADA has advised that under its pandemic regulations, and yes, they actually had pandemic regulations on this, not on COVID-19, but SARS and other public health issues, that when the public health is at risk, as in a pandemic, that these kinds of procedures will override personal protections. And so you are permitted to take temperatures. I personally feel like taking temperatures is a bit of a false sense of security, because of course we all know that if somebody has a high temp or a elevated temperature, that they could be sick with something else. Some people just have a little variance in their temperatures, and they run a little hot or a little cool. And we certainly know that people who have COVID or have been exposed, may be asymptomatic, may not have a temperature right away. And so I don't think that the two are always synonymous. And so I think it does give us a little bit of a sense of false security. But if you choose to do it, it is important that you have a process in place and that you provide employees with privacy. So when you're taking their temperature, that temperature still is protected health information. And then if you ask health-related questions like, in the last so many hours, have you exhibited these symptoms? And their answers to those questions, again, are protected. So we don't want to have, for like large employers, we don't want to have a line of people out the door waiting to get their temperature taken and answer these questions where other people can hear that information being exchanged. So we need to be sensitive that this information is protected. Travel questions, not necessarily so. You can certainly ask where people have been. I personally am advising clients that I think that you can certainly you can prohibit business travel, and we're recommending that. In terms of personal travel, I'm not sure that you really want to be in a business of telling people where they can and cannot go. But once they go, if they choose to go, then they need to know what the consequences are going to be. And so here we have said that if you travel outside the state of Iowa, we want to know where you're going. And in all likelihood, you're going to be subject to a 14-day stay-at-home quarantine after you return to the state. I think it makes a difference, though, if someone is going to New York City versus if someone is going to northern Missouri to hunt mushrooms. And I've had both of those situations, those questions be posed to me in recent weeks and months. So it depends a little bit, and again, we need to be a little bit flexible on those kinds of things. We want to talk about cleaning response too, about making sure that people have the wipes and the things that are available to people to keep their workplaces safe and clean, that your cleaning crews, if you hire external people to do that, that they are coming on a very regular basis, making sure that they're wiping down door handles, things that maybe we didn't require them to do before. If you are a small location or business and you are asking your staff to do that, then you need to let them know how to do that. The fact that it may seem simple, like, oh, wipe down the door handles, right? But let's talk about what does that really mean? How often do we need to do it, right? How do we need to do it? And that it needs to be done with a chemical cleaner. So, you know, if we're going to expect some extra duties of people, we need to make sure that they're properly trained to do those extra duties. All right, so if you do have an exposure or someone tests positive, then you're going to want to have some documentation from that employee that says this is what the situation is. This is where I've been, so that we can properly notify people. You know, you may have been exposed in the copy room on the 12th floor on Wednesday. You know, something along those lines, so that we know where people have been and we can communicate that effectively to our staff members. So when we're talking about returning and recalling people, if you are like most businesses, you did take somewhat of a hiatus in terms of actually being physical in a brick and mortar location. And so whether you were laying people off or furloughing or having people work from home, everybody left, okay? And now we got to think about moving everybody back, because we cannot allow people to permanently work from home. Keep in mind that you hired these folks for a job, and they have to do that job. And you, at least initially when you hired them probably to do their work not from their living room or not from their home office. They're either going to be out and about doing their job, or they're going to be in your location. Has that really changed? I don't think so. And so we need to make sure that employees don't have some sort of expectation that this is the new normal. That this new normal is going to end, right? We have to make sure that our essential work functions remain essential work functions. And from my perspective, most employees, that means physically returning to where they were supposed to be operating from before COVID-19. When you think about returning people to work, you can think about it in terms of dates. Maybe you want to do wave one. We had wave one of employees come back June 1. And then our next wave is going to be next Monday, June 15th. So we've staggered them 2 weeks apart to kind of get our feet wet, get the procedures in place, make sure we know what we're doing with the first wave of people who were volunteers, basically, ready, willing, and able to come back to work and didn't have any other barriers that prevented them from coming back. So you can choose dates, you can choose shifts, you can choose hours. Some employers I know have said you're on a week and then you're off a week. You're on a week and you're off a week. I do think that requires, you know, some significant cleaning in between weeks, if that's what you're going to do. You may want to shift your hours a little bit, right? Instead of 8 to 5, maybe somebody can come in and work, you know, 5 to noon, and then somebody else comes in from 1 to 7, so that you've got coverage during regular business hours, but maybe you're allowing a little more flexibility in terms of which hours each individual employee may work. A lot of employees will not be ready to return. For whatever reason. So there could be, they still have childcare issues. Just because it's summer doesn't mean that all the summer programming has opened back up. Many summer programs are still not operational. And so that may be a situation that people are wrestling with. Some people may have underlying health conditions, or they are home with somebody who has a health condition that makes them more vulnerable, so they don't want to return. Or maybe they just feel like they're uber productive at home and they think they're better, or they may just feel a little too nervous, a bit of a nervous Nelly. I just don't really feel like coming out of my cocoon yet. I want to continue to work at home. And so you need to be able to differentiate, because first wave, you probably can accommodate most of those requests. But eventually, people may need to get back from home and return to work. Now, I do think, and this has been pointed out in one of the Q&A boxes here, but I do think that we probably have become more aware of flexibility, more things that can be done from home. And so maybe that new normal is to be more flexible. I don't disagree with that. But a lot of it also depends, and I think I have a slide on this in a bit, but it depends on wage and hour laws. So the Fair Labor Standards Act, right, allows exempt employees, you're going to be paid the same amount of money whether you're working 2 days, 4 days, 30 hours, 60 hours, you get the same amount of money. Non-exempt hourly employees, not so much. So I shouldn't say not so much, not at all. That's not the same at all. They're getting paid only for the hours that they are working. And so we really need to be they need to be accountable, and we need to be accountable so that we know exactly what people are working. And so sometimes that presents more difficulty from an efficiency standpoint, a tracking standpoint, a supervision standpoint, when those employees are trying to work remotely. So that is one thing that that bears upon my comments is, how do we deal with the Fair Labor Standards Act and wage and hour laws while still being flexible and getting the work done? So there's plenty of balance that can be done, but those are the things that we need to think about. And we've already mentioned the enhanced protections for our workplaces when we're thinking about coming back to work. Another thing that you probably want to take a look at, which probably hasn't been a high priority, is your employee handbook, right? You've had bigger fish to fry than thinking about updating your handbook. But when you think about it, a lot of the policies that we have in place pre-COVID-19 may not be as applicable. Maybe some of these work from home policies, maybe we can do some of this. Maybe we can allow people to work from home 1 day a week. Do we need to differentiate and change our policies? Is there a different call-in procedure that now we decided works even better than what we had before? Do we need to monitor or change our facility access? Do we need to think about our moonlighting procedures? Obviously, some people took a significant economic hit through this situation, and so maybe people are taking second jobs. Maybe people have already, if they're furloughed from one location, they took on more work at the second location. And so we may need to think about, well, how much undivided attention do we expect from our employees, or is it okay that they have another job? So those are the kinds of things that you need to start thinking about. And so when you start reviewing your handbook and you start thinking, oh, well, gosh, these are things that since COVID, we've done differently, and maybe we need to rewrite the policy, or at least think about whether we should consider a different policy. Every employer has a duty to provide a safe place to work. There's a federal Occupational Safety and Health Act, OSHA, and then there is a state statute. And all employers, in fact, let me go ahead to the next slide here, all employers are required to abide by OSHA. We oftentimes think that doesn't apply to white collar settings, but it does apply, not just limited to manufacturing or construction or agriculture or what we would consider more dangerous occupations, but to everybody. And what this means is that every workplace in the country has an obligation, a general duty to provide a safe work environment. Now, that doesn't mean that we can guarantee that no one will ever be hurt in our workplace, but it does mean that we need to do our best to follow OSHA guidelines, to follow the CDC guidelines, the Iowa Department of Health, so that we are providing as safe of an environment as is possible. The Iowa legislature is currently debating, at least, well, I didn't check today, but my understanding is that they are debating an immunity statute. It's passed one branch of the legislature and is pending at the other, that would provide some immunity for employers who do their best who follow the guidelines, who don't knowingly or intentionally let a sick individual into their workplace. So if you're doing all these things right, then there will be some immunity for people who then try to sue you because they believe that they got sick because of you or failed because you failed to act. I have been asked on occasion whether or not I think a waiver, having employees or visitors sign a waiver that if they come into your location and they refuse, for example, to follow your policies or your requirements, that they agree not to sue you. I frankly think those have very limited legal value. It wouldn't be all that much different is when you take your car into a parking garage and you get the slip. If you notice, lots of times the slip will say you can't sue the parking lot if your car gets banged up while it's in there. But most of us don't read that, and the legal ramifications of that are pretty, using that to hang your hat is not going to carry the day. So I oftentimes think that waivers like that may not be worth the paper they're written on. Now, having said that, though, if you are operating a private workplace, you have the right to refuse entrance to someone. And if someone won't comply with your request to wear a mask, for example, then you can tell them they cannot enter. I also think that it provides a little bit of a bad optics. If you're saying, we think we've done what we can, but because we're not really sure, we want you to sign away your right to take action against us. I'm just really not sure that that's the optics that we want in our workplaces right now. So on the question of waivers, that would be my thought. Okay, just briefly, a little more into OSHA and particularly the COVID situation in the workplace. So before April 10th, if someone were to become ill because of work, you, the employer, were required to report that on what's called an OSHA 300 log. And so basically that would mean that in the case of COVID, for example, it has to be a confirmed case of COVID, and that it meets one or more of the general reporting criteria, which means that it resulted in time away from work or restricted work. And of course, it's going to, because anyone who has a diagnosis of COVID or a positive COVID test is going to be required to quarantine for a period of time, most likely 14 days, and then plus whatever time it takes where symptoms are no longer present. But interestingly then, the last piece that's in red is you also had to show that it's work related. And so prior to April 10th, when there wasn't very much community spread, maybe you could argue that they didn't get it here, right? Or vice versa. I've only come from home and here, and so I must have gotten it here. Well, the OSHA has revised its stance on that at this point, and has said, look, there is so much community spread at this point in time throughout the community, throughout the country, that we are no longer going to require employers to spend time figuring out whether it's work related. Don't spend your time on that. And in fact, if you don't report it, unless you know for certain that somebody contracted it at your location, then you really don't even need to be worried about reporting it because of the community spread. Okay, so if, however, you are a healthcare facility, an emergency responder, you're in corrections, those kinds of locations, then they are saying that those kinds of things are reportable injuries because the likelihood that somebody contracted it while performing their work duties is much higher in those occupations. Okay, so if you don't need to spend a lot of time trying to figure out whether they got it at work or whether they didn't get it at work, and that is true also of workers' comp. And I was just looking ahead in my presentation here, and so I'll put a pin in that, but it also applies to work comp because I do have a slide coming up on that. So I'll wait and talk about that when I get to it on the screen. So when we're talking about OSHA standards, we're really talking again about this general duty clause, that you have a general duty to provide a safe work environment. And that's probably not doing, you've always had that requirement. It's just now with COVID, now we need to be doubly sure that we understand what the CDC is recommending and the Iowa Department of Public Health. So you may need to provide additional eye, face, respiratory type protection. Of course, you're going to increase your sanitation. And these citations are referencing the OSHA standard that may be at issue, and that if OSHA ever came knocking, that they would be looking for these particular items and then could cite you under these particular case citations. We have had that come up a couple of times for our clients where someone, an employee, made an anonymous complaint to IOSHA, Iowa's state brand of OSHA, that said they didn't think that their employer was providing a safe work environment. And so they made that complaint, and OSHA then came out on site and did an investigation to make that determination of whether or not they did think that the employer was taking reasonable steps to protect its workforce. Okay, general duty clause, I've already talked a bit about that. And these slides are going to be available for you, so don't worry about writing everything down as we go. These are going to be emailed out and made available to you after the presentation. So here's the work comp piece. So is COVID-19 covered by work comp? We know that work comp injuries have to arise, or illnesses have to arise out of and in the course of employment. All right, so again, in community spread, it's a little bit hard to make that determination. Back when we were in March, February and March maybe, and we were talking about travel to certain hotspots before every place was a hotspot, or on a cruise ship, right? Those were situations where, gosh, we can say, look, they didn't get it here. We're not sure where they got it, but they were on a cruise, so they may have gotten it there. And so that was a little bit different. Now that we have prevalent community spread, the causal connection between work and COVID-19 are more difficult to prove. So what we are recommending is that it's probably not going to be considered a work comp injury, again, unless you're in those particular healthcare related fields and occupations. But my advice to you is to go ahead and write it up on your first report of injury form and turn it into your insurance carrier if that's something that the employee wants to do, and let the insurance carrier deal with that situation. That's not something that you need to be worried about. Okay, so I'm going to move into kind of the alphabet soup, if you will. Seems like everything that touches employment law has an acronym. We're going to talk about the Families First Corona Response Act, Emergency Paid Sick Leave, and Emergency FMLA. We'll talk about the Americans with Disabilities Act, Family Medical Leave Act, and the Fair Labor Standards Act. So all of those are using acronyms, or I will be using acronyms when I talk about them. So the first one is the FFCRA, and I assume that a lot of you have been dealing with this for quite a while. Particularly in the early days, if it came out April 1st, it certainly seems like it is old news, but in the scope of employment law, something that just was passed and came out April 1st is really still very new. It's just that we all learned trial by fire really quickly. And those of us in the legal profession, but also all of you who are on the front lines dealing with this. And so the FFCRA, yes, it continues to be important. And the reason why, even though we think we know about it, the reason it continues to be important now is because there may be waves of employees who, let's say they were furloughed for a while. If they're furloughed because there was no work to be done, then they weren't eligible for this paid sick time or the EFMLA. Once they are called back because there's work to do, now all of a sudden they may indeed be entitled to take some of this paid leave, even though they've already been off for quite some time, if they were off on an unpaid furlough and were getting unemployment. So the FFCRA is an emergency spending bill. It's effective April 1st through the end of this calendar year. So it only goes through December 31st of 2020. It applies to all public employers, regardless of size, and to private employers with fewer than 500. That may seem a little counterintuitive. The comments to the legislation indicate that Congress felt like those employers who were large enough to have more than 500 were probably already doing some of these things. I think that may be a bit naive, but this does only apply to those with fewer than 500. So probably, I would assume everybody on the call. So one of the things that the FFCRA provides is for the emergency paid sick leave. And this is for every employee, even if they just started work yesterday. They don't have to be there a certain amount of time to be entitled to this leave. If they are a full-time employee, they are entitled to 80 hours of paid time off through the end of this year. Now, keep in mind that if they have used it or they use it now, if there is another wave that may hit us in late summer, early fall, they don't get it again. It's 80 hours total between now and the end of the year, not every time there's another wave, okay? If you're a part-time employee, then it's going to be proportional based on the number of hours that you've worked in a 2-week period. The statute says that you cannot require somebody to use their PTO first, that they have to be allowed to bank that PTO. So this is in addition to any paid leave that you may otherwise provide. So it's based on qualifying under 6 different reasons, but we're really only going to focus on the 4 in red. The reason being that A and F really don't come into play. I've never seen a situation where we've actually had an official stay-at-home order in Iowa, and I don't know that we will at this point. So A and F really have not applied here in Iowa, so we're focusing on the 4 middle things. So an employee may be entitled to emergency paid sick leave if they have been advised by a healthcare provider that they need to self-quarantine because of COVID. Or perhaps they are experiencing symptoms of COVID and they are seeking a medical diagnosis. In both of those cases, we need the employees to provide medical documentation from a healthcare provider. This isn't just, I'm not feeling well, I'm going home, or I feel like I have a cough and I feel I need to self-quarantine for 14 days. To qualify for paid emergency sick leave, they have to have doctor's information, doctor certification. That is important, not only because we want to make sure people truly are entitled to the leave, but if you as an employer are required to provide this, and if you want to seek tax credits, then the IRS is going to require that you be able to demonstrate that these people were truly entitled to it. And so you may not get the tax credit if you can't prove, you may have given it, you may have paid somebody for it, but if you can't prove that they were entitled to it, you may not get the tax credit. So it is important. Under both of these situations, the person is limited. Even if they have a larger salary than this, they are limited to $511 per day. If you are an employee who has been caring for someone who is either in B or C, so they either have symptoms, they've been self-quarantined under doctor's care, they have a diagnosis. If you're caring for someone like that in your household, then you could qualify for emergency paid sick leave. In that instance, though, you are only entitled to 2/3 of your pay, and it's capped at $200 a day. Now, when someone is taking that 2/3 leave, if they choose, you're not required or mandated to do this, but if you want, you can require an employee to use 1/3 of their PTO for that day. So they'd be getting their full pay. 2/3 would be under the emergency paid sick leave, and 1/3 would be under your PTO policy. You just can't double dip. So they only get a total of 100% compensation. The 4th reason why someone would be entitled to emergency paid sick leave is if their child care arrangements have been canceled, closed, unavailable due to COVID-19. Now, when this was school closings, that was pretty easy. Now, we do need to demonstrate that daycare, or now that summer has officially started, that your summer daycare programs, whether it's day camps or whatever may be in place, summer nannies, if those kinds of situations are not available because of COVID, then they may qualify to go ahead and stay home and be paid 2/3 pay for those 80 hours for a full-time employee. The emergency family medical leave then takes that childcare issue one step further, and it says that there is new coverage, and this is only for people who have childcare issues. So they get it's 2 weeks of paid leave at 2/3 time, and then the balance, so 10 weeks, remember FMLA is 12 weeks of time, the balance is going to be for under the Emergency Family Medical Leave Act, and again, it's at 2/3 the regular rate of pay. This is the only statute, the only provision under the FMLA that requires paid time off, and it's for 2/3 for weeks 10 through 12 for child care issues. Now keep in mind though, the old FMLA still exists, so if you have 50 or more employees and you're required to comply with the FMLA, people still only get 12 weeks of leave. So if they take 12 weeks here and then they get sick in October, they're not going to have FMLA protection. It's 12 weeks total. In this case, employees do have to have worked for you for at least 30 days to be eligible before they need the leave. And this is available to all employers, even those who were not previously covered by the old FMLA. So even if you have fewer than 50 employees, if you have 10 employees, you're going to have to provide this leave if people qualify. Okay, let me pause there. I'm going to slip back just a second here because I do see a question. The question is, can an employer choose to pay an employee full pay and not use PTO? And yes, that is permissible. You can always do more than the law requires. So you could make them save their PTO. You could have them use their PTO. So you can handle it either way. But do keep in mind that anything you do is setting a precedent. Okay? So if you're going to do for one, you have to be prepared to do for all. And so I really encourage you to think about what's best for everyone, not just best for that one individual. All right, so I do see another question about documentation, and I'm coming to that, so just hold that question for a second. Documentation, here it is. So when we're talking about documentation, you are not required to turn in any documentation to anybody at this point in time. The only reason that we require documentation to validate the emergency paid sick leave or the emergency FMLA leave is because the employer wants to get their tax credits, okay? So if we get the tax, the DOL does not care about some of these things. Like let's look, for example, on the slide we've got, if somebody is going to be absent for emergency paid sick leave, and they are quarantining or they have symptoms, we have to have documentation from a healthcare provider. I think I mentioned that earlier. The next one though, childcare issues. Okay, this is when the documentation gets a little dicey. We need documentation to prove that the daycare or the summer care program is closed and that there is no other suitable provider. So if there is a spouse who is a stay-at-home spouse, or they work nights, or grandma can come in, if there is some other suitable provider, then that needs to be the first line of defense here. But generally, you have to demonstrate that your daycare or your science center day camp or whatever it might be is not operational because of a COVID situation. Now, if your children are between the ages of 14 and 18, generally people assume that children who are that old should be able to stay by themselves, at least during daylight hours. If your children are special needs children, for example, and they need to have an adult in the home during daylight hours, then the employee simply has to write out a statement that says, yes, in fact, this is why I need to be at home. This is why my child needs adult supervision, even though they're age 16, 17, whatever it may be. The DOL, the Department of Labor, is not requiring that. It's the IRS that is requiring that particular statement of special circumstances, and that is to ensure that you get your tax credits. Okay? So we've talked a little bit about using 2/3 pay under the FFCRA and then having the balance as PTO, and that's fine. My recommendation, though, is that if you haven't already, you might want to think about a form. We have developed some forms here, and I've worked with employers to review their forms to say, because this is a lot to keep track of, right? And we need to make sure that we are tracking people appropriately, that we're crediting if they're getting 2/3 of this pay, they're getting a third of PTO, or whatever the case may be. So we want to make sure that we know for payroll purposes and that the employee knows, because their banks are being depleted and they need to know when that happens. So developing a form or a process, a flow chart is useful and helpful. One of the questions is, how do you document that there's no other suitable provider, and who decides that? Excellent questions. I will tell you that my group of lawyers in labor and employment here, my practice group, we've had this debate ongoing, and we don't all agree. And there's not been a lot of guidance on what that means. So I'm going to tell you that you use your own best judgment. It is the employer's decision, because ultimately the employer is the one who is paying the paid sick leave and getting the tax credits, that it needs to pass your gut check to know whether they have made suitable inquiries to determine if there's another provider that's available. In the question that's posted, what happens when dad works nights and he still needs to sleep during the day? I mean, I would say that he's not available then. So I think that but that's a judgment call. I don't think that a parent should be going without sleep in order to provide childcare. It's probably not safe for anybody. So, you need to be practical, but we also need to make sure that we have done our due diligence. Okay. So from my perspective, intermittent leave is advisable. Intermittent means that if an employee wants to, let's say they can telework for, let's say, from 8 to noon, and then their spouse, who's also working from home, takes over and they need to work then from 1 to 5, and your employee then is going to provide the childcare. So you're splitting shifts, and so you're paying them for 4 hours of work. I mean, if they're working, they're getting paid, and then the balance of that day would be used as intermittent emergency paid sick leave or emergency FMLA. You are permitted, and I would think it would be advisable to go ahead and allow intermittent leave under both circumstances. It's permissible as long as both the employer and the employee agree. Okay. So just keep in mind that if you have 50 or more employees, that nothing has changed with respect to the old FMLA. If someone has a serious health condition, which may in fact be COVID, if they have that serious health condition, they're entitled to 12 weeks of unpaid job protected leave. And that hasn't changed. So now what happens though, from a practical standpoint, what happens when somebody runs out of all this stuff? Because quite frankly, they're going to, right? The longer we're out of the workplace, the more likely it is that they're going to run out. And if we have another wave of this that comes through before December 31st, again, we're going to need to know what to do next. So I've run through a couple of scenarios here that I have been asked and come across on a repeated basis. And this is assuming that work is available, okay? So scenario A, employee cannot return to work because of their childcare issues, okay? If they have used up their 80 hours of emergency paid sick leave, they have used up their 12 weeks of EFMLA, and they are now out of PTO, and it's a child care issue, then you are legally permitted to consider termination. Now, whether you do that or not is a different question, okay? Again, as I mentioned earlier, you can go beyond what the law requires or permits, but just know that there are consequences with that and that you may be setting a precedent. So you can terminate under those circumstances. So scenario B, the employee says, I don't want to come back because I'm worried. I don't have symptoms. I'm not sick. I didn't test positive. I don't have children at home. I'm just worried. So they're out of emergency paid sick leave. They're out of PTO. We don't have to worry about the EFMLA because that didn't count, right? They didn't have kids at home. And we also don't have to worry about the FMLA because they're not sick, right? They're just worried. So you can consider an ADA type accommodation. And so that would be a situation where you would say, okay, is there a medical reason why you can't return to work? Maybe someone legitimately has anxiety, depression, whatever it is, an underlying condition that is making it impossible for them to come back to work. We need to then have medical documentation from a healthcare provider to justify that. And then we have to decide, okay, can we reasonably accommodate additional leave or can we not? Does it pose an undue burden on the organization if we were to continue to allow that person to be gone without pay? Scenario C is if the employee can't return due to their own serious health condition or the health care of another, and the person actually has symptoms that constitute a serious health condition. So they're out of EPSL, they're out of PTO, they're even out of the FMLA, right? So now we're done 12 weeks, right? Whether it was paid or unpaid. Again, the only next step is considering an ADA accommodation. And I would just be cautious about whether or not you can continue to accommodate unpaid leaves. You may be able to, you may not be able to. But keep in mind that you need to make sure you tell employees that if you choose to accommodate that for some period of time, whether it's 2 weeks or 3 weeks or 4 weeks, that there is an end in sight, or at least that we will accommodate you for now on a temporary basis. I have had an employer say they will accommodate someone until a vaccine is found and widely available. I think that is a little bit dangerous because frankly, we just don't know when that's going to be. So we don't want to make promises that we can't keep. And we can't just keep people on the books forever, particularly if there are benefits at stake. Your healthcare providers or your healthcare insurers have requirements as to how many hours someone has to work to be eligible to get the benefits. And so if you have allowed somebody to be off and to continue to get benefits and they haven't worked the requisite number of hours, and then let's just say, heaven forbid, they get into a car accident, right, and they turn in a claim of their medical insurance, and the insurance company says, well, we really don't even owe an obligation to health insurance because they didn't work enough. And so we need to be very cognizant of that and careful of that. So I've talked enough about the ADA probably. Okay, so the Fair Labor Standards Act, I did mention this earlier. So when you're bringing back or having people work from home and they're non-exempt, meaning they are not subject to overtime requirements, and that they get a set salary. I said it backwards, I apologize. Non-exempt, yeah, no, I did say it correctly. I'm sorry, I'm second guessing myself here. I'm just looking at my slide. So I'm gonna correct this slide, okay, because it's the exempt people that have no issues. All right, we need to make a little correction there. So the first bullet point should say exempt employees, there are no issues. Non-exempt, the ones that are subject to overtime, that are hourly level employees, we do need to just be cognizant of those issues with respect to the Fair Labor Standards Act, because we are required to pay them for all hours that they work, even if we aren't seeing them in our brick and mortar locations. And so we need to make sure that we have not reduced their salary or their hourly wages unfairly. So we need to make sure that we are following the Fair Labor Standards Act as well. Okay, so some takeaways. So in terms of a summary really of what we've been talking about, we want to make sure that we are staying current on CDC and state recommendations. It is very hard sometimes to get information that we feel is accurate, that we feel is, you know, how do we know what's right or what's wrong? So my advice is to follow the CDC guidelines and the Iowa Department of Public Health. It is less likely that you will be second guessed if you follow their guidelines. Just know that we're gonna have to be flexible because the spread may change, peaks may increase, that we may have some valleys, we may have more peaks later. So we're gonna have to have some flexibility. But flexibility doesn't mean that you haven't planned for it. And so it really is important that you commit some of these things that we've been talking about to writing, that you have a plan in place. You can't just wing it. I don't care if you have 100 employees or 2 employees. You can't just wing it. You have to have thought about these things. If you are going to have supervisors, if you have a workspace is big enough that you have supervisors and managers, you need to going to need to make sure that they understand what the call-in procedures are, what to do if someone comes to them and says they're sick, what kind of travel is permissible. Are we going to deal with discipline issues? If somebody says, I can't come back, they push and say, I'm not returning to work. You know, are we going to require masks? What's our PPE requirements? So we need to make sure that we are training our supervisors and managers and employees and that we are communicating with each one of those groups. What I have found is that employees understand that we're all new to this and that we are a little bit in flux. I think what employees can't forgive, and frankly, nor should they forgive, is an employer that sticks its head in the sand and doesn't respond. The response may not be perfect. It may not be what the employee wants, but at least the employee knows what's expected, knows what the stand is, knows that they are being provided with the best information possible. And so I think that that communication piece is really important. I don't know that I said this, but it occurs to me as I'm looking at my notes and thinking back on things. You know, I know a lot of you have employees who don't just work. I mean, the choice is not necessarily work at home or work in a brick and mortar office, right? You're often out and about. You may be in hospitals or clinics or shelters or wherever. And so, you know, what is the safety protocol there? Hopefully, if you're going to hospitals, right, you're going to be abiding by their protocol, and they're going to be providing temperature checks, masks, all of those things that are required. In all of those situations, you can continue to do your good work, but we do need to be mindful of those restrictions, and we need to be mindful of social distancing. And while it would be great if we could be physically closer to one another, if we could, in many instances, just a simple handshake, right, but a touch or something that we can't do right now. And that's perhaps unfortunate, but that's the way we have to operate. But, you know, maintaining that social distance, and if you can't maintain that social distance, making sure that you have a mask, washing hands, using gloves if necessary, all of those PPE, those things are even more important when, as a result of their job, employees are being asked to go into locations where the risk of exposure could be higher. So I think that that's the end of my prepared remarks, but I will be happy to address questions that some of you may have. I don't know, somebody who's been reading all the questions can tell me if I missed anything, and I'm happy to answer those as well. So I don't know if you want to unmute or how you want to do this, but I'm happy to talk through some of these issues, or if any of you have situations or feedback like this is how we did it, and you know, things that we can all learn from, that'd be great too. I'm just looking at the questions to see if I answered them all. Talked about masks, we talked about documentation, full pay. One of the questions that maybe I didn't explicitly say, the question is, do you have to have documentation from a healthcare provider only if you are seeking the tax credit? That's true. I mean, you can provide leave to your employees. You can provide unpaid, paid leave. Generally speaking, leave is not something that is like PTO, not mandated by the government. And so you can provide that or not as you see fit. In this particular case, you can certainly give paid leave to people who may not otherwise qualify, but if you want the tax credit, you have to have the documentation. Are there any other questions? I'm not seeing questions, but I'm also not seeing anybody else visually either. So unmute or let me know if we want to wait or if there are questions.
Yeah, if we just want to wait a minute here, if you have a question and you don't want to chat or type in the Q&A box, you can raise your hand as well and we can go ahead and unmute you. It's rare that we have a workplace attorney to consult with here, so ask away.
Now's your opportunity for some free legal advice, right? You know, as I did stumble on that FLSA slide because it caught me a little off guard, and now that I'm sitting here looking at it again, it is accurate. I went back and forth in my head, and so I'm sorry that seemed muddled and flustered. But when we're bringing back employees in waves, I mean, the key thing to remember is that when you have exempt employees, if you're trying to bring them back in anything less than a week, that could jeopardize their FLSA status. Because remember, we're paying exempt employees the same amount, whether they work 1 day, 5 days, whether they work 30 hours or 50 hours. So if you're thinking about bringing people back in waves, you can bring them back. Like if they're an hourly employee, you bring them back, you can bring them back for a day or a week or 3 days or whatever. You're only paying them for the hours they work. But when it comes to an exempt employee, then it gets a little bit more muddy. And so we do need to make sure that we are paying them for a full week. You can require exempt employees to pay or to use their PTO bank. You can require that if you choose, so that they'd be getting their full salary. It's just that their PTO bank would be being diminished over the course of the weeks that they are not working all 5 days. So hopefully that makes sense, and I'm sorry if I confused that issue when I was speaking, but the slide is accurate, and like I said, that'll be made available to everybody after the presentation.
Well, thank you so much, Mary, for joining us and sharing your wisdom with us. We will send the PowerPoint out to everyone via email, just a reminder, and then also have the recording if you have any other leaders in your organization that would like to view this. And then please, just a reminder to fill out the evaluation after this training.
Okay.
All right, everyone, take care. Thank you.
Thank you. Have a good day, everyone.